Well, a 10-year-old boy fell about 20 feet while he was ziplining, hit the concrete below, and now his mom is suing the zipline company. We're about to show you what happened. Some of you might find this video disturbing, and we have frozen it, though, before the boy hits the ground. Again, here it is. The 10-year-old, we know, as you see it happen here, had to be airlifted out to a hospital. He suffered several broken bones, a collapsed lung, and a brain injury. Now, this happened in September. He's trying to go back to school, but his mom says every day is a struggle for normalcy. So let's bring in John Phillips, personal injury attorney, joins us via Skype from Jacksonville. John, good to see you. So the family's filed a lawsuit seeking in excess of $15,000. Let's go over what an inspector is saying, that the equipment was fine, no history of trouble here, but video shows the boy's harness was not fully secured. You can see the leg straps not buckled. They call it operator error. Does that equal this family wins the lawsuit? Is that it?
It generally does. So these zip lines aren't very regulated in Florida. The Department of Agriculture only inspects them if called to inspect them. But the issue wasn't in the design of the system. It was that the employee forgot to harness the boy in, and so he went flying down and fell out of the harness. It should be a victory under Florida tort law.
Yeah, well, here's the statement from the company. It's Urban Air Trampoline and Adventure Park in Lakeland, Florida. Here's their statement. As a family-owned and operated company, safety is at the heart of everything we do. We take matters of this nature very seriously and can assure that appropriate measures have been taken. So how do they fight this lawsuit?
It depends on how it actually happened. A 10-year-old boy is not going to be liable under Florida law. So if this were an adult, they could have blamed the adult to some extent, saying you should have strapped yourself in or made sure you were strapped in. A 10-year-old's not really liable for that type of safety measure. I think it's just where they attack damages. They've already said in their statement he's back in school. They're kind of downplaying damages. They've just got to do damage control as best they can.
Got it. The requested amount from the family in excess of $15,000. Is that enough based on the injuries, broken bones, collapsed lung, brain injury, and again, normal life's a struggle right now?
I suspect they're suing for way more than that. $15,000 is the minimum you have to plead to get into circuit court. So really that number doesn't mean anything other than we qualify for the court that we're in. I suspect it'll be a 6- or 7-figure demand that they make.
Gotcha. In your line of work, do you deal with this a lot? And I think we're all looking, okay, what's the word to parents out here? It's autumn. People like to get out and about and do things like this. How do we make sure the family stays safe?
We have multiple cases against these zipline companies, and people need to understand they're not highly regulated. We've got one case where a grown man ziplined right into a tree that was covered by swimming pool noodles, of all things. So that tells you there's no real safety standards when swimming pool noodles are supposed to stop you. Those are not designed for that. And so you just got to be careful with using any entertainment device and inspect and make sure the inspectors are inspecting to keep you safe.
Yeah. Do your homework at the end of the day. John, always good to see you. Thanks so much.